Legal and regulatory compliance requirements. Law is a system of rules that state what we can and cannot do. These rules are put together to ensure that everyone's rights are protected so that we can live freely and peacefully. Whether it's paying for meals, stopping at traffic lights, the law is required to protect people from being harmed by others. Breaking the law may result in having to face certain consequences depending on how serious the offense is. It could be anywhere from paying a small fine all the way to some serious jail time. Law has been defined both as the science of justice and the art of justice. Legal system refers to a procedure or process for interpreting and enforcing the law. It elaborates the rights and responsibilities in a variety of ways. Security professionals must understand the different legal systems that are used throughout the world and the components that make up the systems. Civil code law, developed in Europe, is based on written laws. It is a rule-based law and does not rely on precedents in any way. The most common legal system in the world. Civil code law does not require lower courts to follow higher court decisions. Common law, developed in England, is based on customs and precedent because no written laws were available. Common law reflects on the morals of the people and relies heavily on precedents. In this system, the lower court must follow any precedents that exist due to higher court decisions. This type of law is still in use today in the United Kingdom, the United States, Australia, and Canada. Today, common law uses a jury-based system, which can be waived so the case is decided by a judge. Common law is divided into three systems: criminal law, civil/tort law, and administrative/regulatory law. Criminal law covers any actions that are considered harmful to others. It deals with conduct that violates public protection laws. But the prosecution must provide guilt beyond a reasonable doubt. Usually the civil body, such as the state or federal government, that establishes the law that is violated. In criminal law, guilty parties might be imprisoned and/or fined. Criminal law is based on common law and statutory law. Statutory law is handed down by federal, state, or local legislating bodies. Civil law deals with wrongs that have been committed against an individual or organization. A defendant is liable for damages to the victim if the defendant had a duty of care to the victim, breached that duty, was negligent, and was the actual cause of harm to the victim. Under civil law, the victim is entitled to seek compensatory, punitive, and statutory damages. Compensatory damages are those that compensate the victim for his losses. Punitive damages are those that are handed down by juries to punish the liable party. Statutory damages are those that are based on damages established by laws. In civil law, the liable party has caused injury to the victim. In the United States, civil law allows senior officials of an organization to be held liable for any civil wrongdoing by the organization. So if an organization is negligent, the senior officials can be pursued by any parties that were wronged. In administrative law, standards of performance or conduct are set by government agencies for organizations and industries to follow. Common sectors that are covered by administrative law include public utilities, communications, banking, safety and environmental protection regulations, and health care. Customary law is based on the customs of a country or region. Customary law is not used in most systems in isolation, but rather incorporated into many mixed law systems, such as those used in many African countries, China, and Japan. Monetary fines or public service is the most common form of restitution in this legal system. Religious law is based on religious beliefs. Although most religious law will be based on a particular religion and its primary written rules, Cultural differences can vary from country to country and will affect the laws that are enforced. Mixed law combines two or more of the other law types. The most often mixed law uses: civil law and common law. In American law, a regulation is a rule that is laid down by an administrative agency pursuant to an enabling statute, to wit, a piece of legislation that says this agency shall do these functions, and it may promulgate regulations consistent with that end. A rule is a rule of court. Security professionals must be aware of the laws, rules, and regulations, at a minimum understand how those laws affect the operations of their organization. Gramm-Leach-Bliley Act, GLBA, of 1999. GLBA affects all financial institutions, including banks, loan companies, insurance companies, investment companies, and credit card providers. It provides guidelines for securing all financial information and prohibits sharing financial information with third parties. This act directly affects the security of PII. Computer Fraud and Abuse Act, CFAA, of 1986. CFAA affects any entities that might engage in hacking of protected computers as defined in the Act. It was amended in 1989, 1994, 1996. In 2001 by the Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct terrorism, USA Patriot Act. In 2002. And in 2008 by the Identity Theft, Intent and Restitution Act. A protected computer is a computer used exclusively by a financial institution or the U.S. government, or used in or affecting interstate or foreign commerce or communication, including a computer located outside the United States that is used in a manner that affects interstate or foreign commerce or communication of the United States. The Federal Privacy Act of 1974 affects any computer that contains records used by a federal agency. It provides guidelines on collection, maintenance, use, and dissemination of PII about individuals that is maintained in systems of records by federal agencies on collecting, maintaining, using, and distributing PII. Federal Intelligence Surveillance Act, FISA, of 1978. FISA affects law enforcement and intelligence agencies. It was the first act to give procedures for the physical and electronic surveillance and collection of foreign intelligence information between foreign powers and agents of foreign powers, and only applied to traffic within the United States. It was amended by the USA Patriot Act of 2001, the FISA Amendments Act of 2008, and the USA Freedom Act of 2015. Electronic Communications Privacy Act, ECPA, of 1986. ECPA affects law enforcement and intelligence agencies. It extended government restrictions on wiretaps from telephone calls to include transmissions of electronic data by computer and prohibited access to stored electronic communications. It was amended by the Communications Assistance to Law Enforcement Act, CALIA, of 1994. The USA Patriot Act of 2001, and the FISA Amendments Act of 2008. The United States Federal Sentencing Guidelines of 1991 affects individuals and organizations convicted of felonies and serious, Class A, misdemeanors. It provides guidelines to prevent sentencing disparities that existed across the United States. Communications Assistance for Law Enforcement Act, CALIA, of 1994. CALIA affects law enforcement and intelligence agencies. It requires telecommunications carriers and manufacturers of telecommunications equipment to modify and design their equipment, facilities, and services to ensure that they have built-in surveillance capabilities. This allows federal agencies to monitor all telephone, broadband internet, and voice over IP, VoIP, traffic in real time. Personal Information Protection and Electronic Documents Act, PIPTA. PIPTA affects how private sector organizations collect, use, and disclose personal information in the course of commercial business in Canada. The Act was written to address European Union, EU, concerns over the security of PII in Canada. The law requires organizations to obtain consent when they collect, use, or disclose personal information and to have personal information policies that are clear, understandable, and readily available. Basel II affects financial institutions. It addresses minimum capital requirements, supervisory review, and market discipline. Its main purpose is to protect against risks the banks and other financial institutions face. It is an international accord, and compliance is not mandatory. Federal Information Security Management Act, FISMA, of 2002. FISMA affects every federal agency. It requires the federal agencies to develop, document, and implement an agency-wide information security program. The Economic Espionage Act of 1996 covers a multitude of issues because of the way the Act was structured. This Act affects companies that have trade secrets and any individuals who plan to use encryption technology for criminal activities. A trade secret does not need to be tangible to be protected by this Act. Per this law, theft of a trade secret is now a federal crime, and the U.S. Sentencing Commission must provide specific information in its reports regarding encryption or scrambling technology that is used illegally. USA Patriot Act of 2001. The USA Patriot Act affects law enforcement and intelligence agencies in the United States. Its purpose is to enhance the investigatory tools that law enforcement can use, including email communications, telephone records, internet communications, medical records, and financial records. When this law was enacted, it amended several other laws, including FISA and the ECPA of 1986. The Healthcare and Education Reconciliation Act of 2010 affects healthcare and educational organizations. This act increased some of the security measures that must be taken to protect healthcare information. The USA Freedom Act of 2015 reauthorizes parts of the USA Patriot Act but dissolves its notorious bulk data collection of Americans' phone records and Internet metadata. European Union has implemented several laws and regulations that affect security and privacy. European Union principles on privacy include strict laws to protect private data. European Union Data Protection Directive provides direction on how to follow the laws set forth in the principles. European Union created the Safe Harbor Privacy Principles to help guide U.S. organizations in compliance with the EU principles on privacy. Safe Harbor is an entity that conforms to all the requirements of the EU principles on privacy. Data should be collected in accordance with the law. Information collected about an individual cannot be shared with other organizations unless given explicit permission by the individual. Information transferred to other organizations can be transferred only if the sharing organization has adequate security in place. Data should be used only for the purpose for which it was collected. Data should be used only for a reasonable period of time. A data haven is a country that fails to legally protect personal data, with the main aim being to attract companies engaged in the collection of the data. The Safe Harbor privacy principles were replaced by the EU-US Privacy Shield. It provided a framework for transatlantic personal data exchanges for commercial purposes between the European Union and the United States. The EU Electronic Security Directive defines electronic signature principles. The EU Electronic Security Directive defines electronic signature principles. In this Directive, a signature must be uniquely linked to the signer and to the data to which it relates so that any subsequent data change is detectable. The signature must be capable of identifying the signer. Beginning on May 25, 2018, the members of the EU should begin applying the General Data Protection Regulation, GDPR. The GDPR applies to EU-based organizations that collect or process the personal data of EU residents and to organizations outside the EU that monitor behavior or offer goods and services to EU residents. It gives a wider definition of personal and sensitive data to include online identifiers and genetic and biometrics data, such as cookies, IP address, health information, biometric data, and genetic information. The GDPR affects service providers that process personal data on behalf of an organization, including cloud services, call centers, and payroll services. Organizations must follow stricter rules for consent as a legal basis for processing. Organizations must be transparent regarding what information is collected and how the information is processed. Organizations must allow individuals to correct inaccurate personal data. Organizations must allow individuals to request that their personal data be erased under certain conditions. Organizations must allow individuals to move personal data from one service provider to another. Organizations must not use automated processing as the sole decision maker. Under GDPR, organizations are obligated to provide accountability by maintaining a record of all data processing activities. A Data Protection Impact Assessment, DPIA, is mandatory if processing activity is likely to result in a high risk to an individual's rights. Organizations must keep personal data secure through appropriate technical and organizational measures. Organizations that are public authorities, monitoring individuals on a large scale, or processing sensitive data must name a data protection officer. For all other organizations, a data protection officer is recommended but not required. Data transfer outside the EU is allowed only if appropriate safeguards are in place. Organizations that do not comply with GDPR can be fined up to €20 million. In addition, they may have to compensate victims for damage claims. Non-compliance in GDPR may result in reputational damage and consumer loss of trust.